I'm kind of short here, so I might just hold it like this and have my diva moment. But just want to start off by saying I ask my elders to forgive me while I speak in my language. Noa sa'asanesh deshtadeo. Greetings to you all in my Arikara language. My name is Vicky Alberts. My traditional name is Blue Corn Woman, and I am an enrolled member of the 3 affiliated tribes, but I also represent the Spirit Lake Dakota and Standing Rock Lakota Hunkpapa tribes. I am currently serving as the outgoing president of the Native American Law Student Association, and I'm very honored that we have our special guest here today. He is a very prominent voice in Indian country and in federal Indian law, and so we're very excited to welcome him here. I also want to take this time to acknowledge the Native American Law Student Association Board, who has put in many hours and dedicated their time and energy to a very successful year for us. We do our best to offer programming that promotes federal Indian law as well as tribal law, because that is American law. So at this time, I'd like to acknowledge Kay Lee Baker, our Vice President. Give him a round of applause. Our Treasurer, Mr. Francis McCullough. Our Secretary, Ms. Michelle Belgard. And our 3L Rep, Marissa Saceda. We could give a round of applause as well for Mr. Jacob Lowing. He's our social media director, but unfortunately he had work obligations. And to the man behind the curtain, the one who supports us throughout our entire journey, Mr. James Grijalva, our advisor. So today is a very special time because not only do we have our distinguished Indian law speaker, but we also have a distinguished guest among us. And I don't only say that because he's my relative and uncle, but he is also the former chairman of the 3 affiliated tribes from 1978 to 1982. And his political career within our tribal government has spanned over 4 decades. Don't mean to make him sound old, but he is one of the most unique individuals, and he is the person that we have to give credit for our connection to Mr. Echo Hawk. Without his friendship with Mr. Echo Hawk, I don't think we would have been able to secure him as a speaker. So at this time, I'd like to acknowledge Mr. Austin Gillette, if you would please stand. Mr. Gillette is a Vietnam vet who served in the United States Marine Corps, and when I told him that Mr. Echo Hawk had confirmed, he said he wanted to come and honor his friend, and so he will be singing an honor song to help us honor Mr. Echo Hawk. So we really appreciate him traveling quite a distance to come and be with us here today. And with that, I'd like to turn things over to Professor James Grijalva for the introduction of our distinguished Indian law speaker.
Thank you, Vicki. Thank you, Vicki. I feel it's very, hello, everyone. Welcome. This is the School of Law's annual Distinguished Indian Law Lecture event. We hold this event every year in conjunction with the university's Time Out Week, which honors the very significant number of Indian-related programs across the campus, and the Native American Law Students Association and our certificate in Indian and Tribal Law is part of that robust attention to issues affecting indigenous communities in this country and across the country, across the world, excuse me. As Vicki said, I'm Jim Grijalva. I am the advisor to the NALSA chapter, our student organization, and I really appreciate the effort of the board and also the members this year for a tremendous year. We also, as many of you know, Time Out ends the week of programming with a traditional wachipi or powwow, kicking off the season. And somehow or another, we got wrangled into running the taco stand. So I hope to see many of you there with money in hand because we'll be serving you. I'm very privileged to be the person to introduce Walter Echohawk today. This gentleman is a truly exceptional human being. He's a citizen of the Pawnee Nation, and today he's going to bring to the podium over 5 decades of legal experience and wisdom from decades as a lawyer, as a jurist, as a governmental leader, a scholar, and a teacher. The breadth of his accomplishments are even more impressive when you consider that he became a lawyer in 1973. Graduated from the University of New Mexico, joined his cousin John, who had started a public interest law firm called the Native American Rights Fund, which is today the preeminent public interest law firm working for tribes, tribal sovereignty, and indigenous peoples. But in the 1970s, especially the early 1970s, the systemic obstacles for him to even become a lawyer were tremendous, maybe nearly insurmountable. His timing, though, was fortuitous because that was also the time the federal government officially rejected its former policy of terminating the formal relationships between the federal government and the many indigenous nations of this country, which had disastrous consequences and resulted in several presidents calling, and then for Congress following in the early 70s, a new policy called self-determination. The idea that no longer would federal officials be the ones making day-to-day decisions for Native people in Native country, but that tribal governments would take their sovereign role along with states and the federal government to make decisions, to implement programs, to run the kinds of services that every government provides to its citizens, but to do that in ways that prioritize tribal values and were consistent with cultural heritage. Promises of the federal government, of course, are easy to make and somewhat harder to keep, it seems. Walter Echohawk began his career with this vision to hold the federal government accountable. And at NARF, he represented Indian tribes across a wide variety of areas. Federal Indian law is an incredibly complex area, and the breadth of his accomplishments are quite amazing. When you think about the ends of the spectrum, or a circle maybe more appropriately, representing tribes on the quantification of their water rights. As many of you know, many rivers were allocated to non-Indians and to states without the participation of tribes who had the first in time right to the water that had been taken from them. And tribes are still fighting those battles today. Incredibly complicated area of the law. But Mr. Echohawk also represented several tribes on treaty rights, rights to hunt, fish, and gather, promised solemnly by the United States federal government in exchange, of course, for millions of acres of indigenous lands. He sought the return of the tribes, various tribes' ancestors of their very bodies and their sacred funerary objects, as well as protecting individuals in many cases, especially with respect to individual indigenous religious rights. The courts of the conqueror, unfortunately, have not always been reliable in following even their own rules. So Mr. Echohawk worked with tribes to ensure that Congress stepped in to correct some of the mistakes of the courts and played key roles in the enactment of several federal statutes, including the Native American Grave Protection and Repatriation Act, amendments to the American Indian Religious Freedom Act, and an act that established the National Museum of the American Indian, but which also incorporated a separate agreement that had been made prior by the Smithsonian to return the tens of thousands of bodies and articles of indigenous cultural patrimony that they possessed to their rightful homes. Mr. Echohawk has also used his legal acumen in the direct exercise of tribal sovereignty. He served as a Supreme Court justice for 2 tribes, his nation, the Pawnee Nation, as well as the Kickapoo, and ended up becoming president just about the same time COVID showed up. And so he was the president of the Pawnee Nation Business Council for the 3.5 or so years of the COVID pandemic and its associated economic and social struggles. He's widely shared his wealth of knowledge through books and articles, through teaching at various law schools, and by joining us today. I'm very happy to announce, and I will ask that you join me in welcoming as our distinguished Indian law speaker, Mr. Walter Echohawk.
Gee, I can't wait to meet him. Thank you, Professor, for that wonderful introduction. I was wondering, is Mr. Gillette, is this the time for him to afterwards? Oh, okay, thank you. And also, I'd like to acknowledge the Dean. Thank you for being here, sir. It's quite a great privilege for me to return to the law school. I just wanted to mention there's a lot more people here than the first time I came, which was back in the 1990s. And I had an audience of one person. But the show must go on, is what I said to myself, and I delivered what might be my best talk ever. But I'm very glad to be here. Noa chahix takitu, iriwe turahe, weitatu deriku. It's good to see each one of you. I am very glad to be here at the law school. And I want to thank the good professor and also Vicki for my invitation to come to this wonderful law school. Also to Professor Dan Leverance for showing me around and having a wonderful time. A lot of wonderful courtesies have been extended to me, during my stay here, and I appreciate that very much. And Vicki, I want to thank you again for reaching out to me and inviting me to be here, and to each and every one of you for being here. I appreciate that very much, and I'm glad that we were able to acknowledge my good friend Austin Gillette and his better half, Rosie, that are here with us today. I'm very honored and humbled to be the 2024 Distinguished Indian Law Speaker today. And my topic is challenges for federal Indian law practitioners in the decade ahead. And what I'd like to do with the time I have up here is to discuss 4 big challenges for federal Indian law practitioners that I foresee in the decade ahead. The first is to forge a stronger role for tribal governments in the government-to-government consultation with the United States federal agencies on a nation-to-nation basis. The second is a challenge for our new attorneys that are coming forward, is finding ways to use the indigenous knowledge, the co-stewardship, the co-management opportunities that have recently been created by the Biden administration to protect tribal rights and interests on former tribal lands that are managed by federal agencies. The third challenge that I want to talk about here is environmental in nature, and that would be the role of tribes, defining the role of tribes in the paramount challenge that the human race faces today, and that is the problem of climate change, which threatens life as we know it in this warming world. And I think that our tribal people, our traditional culture bearers, carry some indigenous knowledge that will help, I think, the human race address that worldwide crisis. And I want to talk about that a bit. And then the next area that I want to talk about is a challenge for using indigenous knowledge, co-stewardship, co-management opportunities, as I mentioned earlier, to actually become co-managers of federal lands, as I mentioned. And then the final area that I wanted to talk about is law reform. the challenge of reforming federal Indian law to make it a more just and a more reliable body of law for defining indigenous rights in the United States. However, before I address these 4 areas, I wanted to first offer my heartfelt congratulations to the graduating 3 Ls who will be graduating next week, the class of 2024, including Vicki. And basically to say to you a few words of hopefully encouragement. Your graduation next week will be a milestone day. After 3 years of hard work and sacrifice, you've earned your law degree, proved yourself. Now your legal career lies ahead. For that, I think we can all be thankful for our professors, and also grateful for all of your mentors, family, and other supporters. I know that over the past 3 years, many prayers have been offered for you, and next week they will be answered. So I wanted to just pause a moment to say that I feel that each of the graduating seniors that you will be, hope that you will be blessed in a very long career. I wanted to share just a few words of advice on some of the big challenges I think that are going to be facing your generation of attorneys as our future law leaders. I myself began, as was mentioned, my career 51 years ago. I am in the twilight of my legal days as an attorney, but your careers are just now beginning, you know, and so we're witnessing a changing of the guard in federal Indian law. But in you and your colleagues, I think that our future in Indian country is in good hands. In the coming years, Native America is really going to need federal Indian law attorneys now, I think, more than ever. We know indigenous rights are never freely granted. They always have to be demanded, fought for, wrested away, and then vigilantly protected. That task calls for warrior-minded attorneys, legal advocates of a certain kind, a special breed, if I may say, to fight for, defend indigenous rights for our native nations and native peoples. And today, as we look around the field, the practice of federal Indian law, most Native American attorneys today work in 3 general areas of the law. It's a very broad and diverse body of law. The one area is to consolidate and protect the gains made by past generations of our forebears here in federal Indian country, the tribal attorneys that have gone before, tribal leaders. And I think to consolidate the gains that they've made over the decades is a task that I think requires tribal attorneys to have a strong expertise and grounding in the principles of federal Indian law and policy. Second area of practice today is to assist our tribal nations in navigating uncharted waters that modern Indian nations now find themselves in. And these issues go well beyond federal Indian law into business finance, labor relations, corporate mergers, and areas of the law that our tribes are facing today that go far beyond federal Indian law. And then the third area of work for many of our members of the bar are to reform and strengthen federal Indian law to make it more reliable body of law in a post-colonial era, 21st century. And these three areas, or this area requires law leaders to really be visionaries and law reformers. So these three areas of work present big challenges in and of themselves. But it's always important to remember that the law does not exist in a vacuum. Rather, it's inextricably connected to the larger society and the world in which we live. And it's in that context that you have to always keep that in mind, because it presents, I think, big challenges for legal practitioners in federal Indian law. For in many respects, we live in a broken world today. And it's going to be up to your generation as our law leaders for the next generation to address these issues and navigate these big factors that shape the larger world in which we live in. And the first of which is the fact that we have this worldwide environmental crisis that threatens life as we know it. And it can no longer be ignored. I think that as attorneys, you must help Mother Earth heal herself, restore the tribal traditional relationship with the natural world, and protect our indigenous habitats throughout North America here. And as a healer, you're going to have to be conversant with your Native American culture, environmental law, and indigenous human rights to address that larger challenge that sits before you. The second area is our deeply divided society in which we live. We look around the country and we see the rise of hate, the rise of racism, violence, mistrust. So attorneys of this generation, peacemakers you must be in your legal work to try to bring unity and goodwill to our diverse peoples here in the United States. For a nation divided, as they say, cannot stand. Thirdly, we see in the larger context here that our democratic norms are under assault. In that regard, on the Bill of Rights, we see book banning going on in the public schools across the nation, attacks on the free press, attacks on the judicial system, our criminal justice system. A Congress that is stymied by partisanship, corruption in high places, and ill will that rules our politics today. So our democracy must right its ship with your help in this coming generation so that our nation will endure. And finally, another big factor that's out there is that our tribal rights are under assault. Scholars have pointed out that the Native America has an 80% loss rate before the U.S. Supreme Court. So, law reformers and social engineers you must be. Rise above the press of daily work to see the larger picture in the practice of law. These challenges are big ones to be sure, but take heart because They're all problems caused by humans. Therefore, they can be solved by humans. In that process, champions will arise, heroes will emerge, and I'd like to see this class of 2024 be among them. So with that, let me turn to this first big challenge that I see in this next decade that I think is really upon our tribes right now to rise to this new set of challenges and opportunities. And this relates to government consultation with federal agencies. And I think that it will be a very important challenge in the near term for federal Indian law attorneys to help tribes to forge a stronger government-to-government consultation framework for engaging with the federal agencies on a nation-to-nation basis. It used to be, way back when I started practicing law, it was the practice that Washington, D.C. made all of the decisions affecting tribes without any consultation whatsoever. They just made the decisions back in Washington, and the tribes lived with them. And but now today, we have this government-to-government consultation whereby the federal government is supposed to consult with tribal governments before they make any decision affecting tribal rights or interests. And this government-to-government consultation is an extremely important form of engagement for tribal nations because it entails, before any decisions are made, an exchange of information between the agency and the tribe, dialogue between the tribal government leaders and the agency leaders, and at the end result is a tribal input into any decision that is made that affects their rights or interests. And so this consultation, we have to remember, is the primary means for engagement by most federal agencies is through government-to-government consultation. And scarcely a week went by when I was president of the Pawnee Nation that I didn't get inundated by consultation requests. But unfortunately, there's been a lot of problems in government-to-government consultation. The framework for it was established by an executive order handed down by President Carter in the year 2000. And that executive order 131-175 not only acknowledged the federal duty to consult tribal governments, but it laid out a tribal consultation framework that required, it had a legal standard of meaningful consultation by agencies with tribal governments before a decision is made affecting the tribe's interests. And it was supposed to afford the tribes a meaningful opportunity for input before these decisions were made. But unfortunately, back in the year 2000, when this was promulgated, the agencies didn't implement it very well. And there was a lot of foot dragging going on. And it generated all kinds of complaints by our tribal government leaders across the country. They said there was foot dragging, that the agencies saw this consultation as unnecessary, as burdensome. Consent was not required. It was just a box-checking exercise with no checks and balances for agency abuse of what was required. that there were too many diverse agency policies, a lack of uniformity. Decision makers were not at the table. And some of the legal scholars basically concluded that this federal consultation framework or policies and laws as implemented was inherently inadequate or fundamentally inadequate, especially on major federal projects that affect tribal lands and waters and resources, and has to be improved. But that situation has started to change now with the advent of the Biden administration in 2020. The Biden administration has really created a brand new era for tribal consultation. First, it acknowledged all of this growing list of tribal complaints over the decades about federal agency consultation inadequacies. Secondly, it lit a big fire under the agencies to address the tribal complaints and to improve their consultation practices. And it's opened a brand new era for tribal consultation through new policy directives that the president has handed down, coupled with implementing regulations across the executive branch. President has basically two new policy documents. One was the Presidential Memorandum on Tribal Consultation of 2021, which reaffirmed the Clinton executive order, and it directed agencies to come up with a consultation set of plans, how they were going to implement that. And it acknowledged a duty to consult, stemming from the unique political relationship between the United States and tribal governments. Then 1 year later, in 2022, President Biden handed down another presidential memorandum on uniform standards for tribal consultation that announced a new consultation standard that consists of meaningful consultation plus striding for consensus or a mutually desired outcome. And so this memorandum prompted all land managing agencies and other federal agencies across the country to begin developing new consultation policies to implement this new standard. And we're seeing the rise of all kinds of new consultation standards that are striding towards consensus with tribes before a decision is made or a mutually desired outcome. So consultation now is more envisioned as a negotiation process where part of the consultation entails a negotiation or a mutually desired outcome or a consensus. So that brings consultation to a new level. And then secondly, on the international level, the UN Declaration on the Rights of Indigenous Peoples, approved by the UN in the year 2006. And this establishes a whole new human rights framework for indigenous rights for Native people around the world, including this free, prior, and informed consent standard for consultation. And with the advent of this UN declaration, with the FPIC standard, as we see, together with the strengthened Biden policies for consultation, we are seeing a new era for stronger consultation between tribal governments and federal agencies today. And that climate creates new opportunities for tribes to take a non-litigation approach to addressing problems in proposals that affect tribal rights and interests, federal proposals, including an opportunity for each tribe across the country to enact tribal law, tribal consultation laws that lays out consultation procedures that are workable for tribes and that embrace this FPIC standard as a standard for tribal consultation on major issues. And so that will be, I think, an area of work for our tribal leaders and our tribal attorneys to rise to this challenge of taking advantage of this new significant policy change, when it comes to government consultation, which has been described as a cornerstone of the federal trust responsibility for tribes, basically the lifeblood of that nation-to-nation relationship. And so I think tribal attorneys will have a role in that process to strengthen. There's about 20 tribes already that have passed tribal consultation statutes, but I think all federally recognized tribes should have such laws in place as basic infrastructure for dealing with the federal government. The second challenge for federal Indian law practitioners that I foresee is to assist our tribal governments in taking advantage of these new Biden-era federal policies with regard to indigenous knowledge, co-stewardship, and co-management, better protect tribal rights and interests, not only in tribal land under tribal jurisdiction, but also former tribal lands that are being managed by federal agencies, land and water managing agencies. The United States is the largest landowner in the country. All of that land is former tribal land, tribal lands and waters that are subject to tribal rights and tribal interests. And so most of our tribal habitat, most of our tribal holy places, and much of our natural resources that our traditional ways of life, our treaty rights pertain to are outside of tribal jurisdiction and under the control of federal land and water managers. Legally, it's been very difficult historically for tribes to protect those off-reservation rights and interests in lands, habitats, waters, and natural resources. They, for decades, have had to rely solely on the federal agencies to protect tribal interests. And when that failed, legal recourse has been very unreliable for court challenges. And under the federal public land laws, federal land managing agencies have been able to find ample ways for states and private entities to have significant say-so in the way they manage federal land and waters. But the tribal interests have been ignored by the states or the federal agencies and excluded from any co-stewardship or co-management opportunities. But again, that situation has now changed under the Biden administration. Not only as a result of these new consultation policies, but also by this joint secretarial order 4303 that was promulgated by the Interior Department and Agriculture Department in 2021. That joint order has subsequently been joined by the Department of Commerce, that includes the NOAA, National Marine Ocean Manager, Water Manager, and it mandates this order of 4303. It mandates federal water managers or land managers to include in their management duties of federal public land and water these agencies to enter into co-stewardship agreements with tribal governments, co-management agreements with tribal governments that have interests in these water bodies, or land bodies. And also to go out and obtain the indigenous knowledge of tribal people and to use it in making land management decisions and land management or land planning. Now, this body of knowledge, back in the 90s, recently as the 90s, co-stewardship was a dirty word for these land managing agencies and water managing agencies. There was no such thing as co-management. And this whole body of indigenous knowledge was looked down upon. It was demonized by most of society. But now, with our warming world, the Biden administration is realizing that that body of indigenous knowledge that teaches us how humans should comport themselves to the natural world contains a lot of environmental teachings that we now desperately need to cope with this warming world that we have created. So they're actively now on bended knee asking the tribes to share their indigenous knowledge and to deploy it in managing these federal properties. So I think that this opens a whole new era for tribes to actually become a co-manager, a co-steward, to deploy its indigenous knowledge, to significantly upgrade the role of the tribal governments in protecting their rights and interests on federal lands and waters, that contain tribal habitats and tribal interests, tribal legal rights. So the burden is on the tribes now to step up and meet those opportunities, and I think that law practitioners of the next 10 years will be integral to helping the tribes step up and meet these opportunities. The third area, and I don't know if I'm running, how am I doing on time? I'm going to try to wind down, Dean. I tend to get lost up here, but the third area is somewhat related. It's on the environmental front. I think that federal Indian law practitioners will have an important role to play in the next decade to help our tribal government and our tribal nations to define and to forge a significant tribal role in addressing climate change. As I alluded to earlier, the Biden administration now is reaching out for tribes to share their indigenous knowledge. This is knowledge of our ancestors that has been handed down through the generations, that's based on millennia of close interaction with the environment of particular places. And it teaches us about Father Sky, Father Sun, how we should comport ourselves to the heavens above, Mother Earth, animals and plants, it's now being recognized by the executive branch under the leadership of President Biden, the White House Council on Environmental Protection and the White House Office of Science and Technology as a body of knowledge that is very important to increasing our environmental protection, something that is sorely needed in this warming world that threatens life on Earth as we know it. So I think that this climate change problem is a paramount challenge that everything else pales in importance in comparison to it that we do on a day-to-day basis. And it's a paramount challenge in the next decade to address this in a meaningful way before it's too late to address it. And I think tribes will have a role. Our culture bearers, our traditional religious leaders, the hunters, fishers, and gatherers among our tribal people retain ancient knowledge, a treasure trove of ancient knowledge about human beings, how human beings should comport themselves to the natural world, something that has been fallen by the wayside in modern industrialized societies around the world. But pockets of that body of knowledge still exist in tribal communities in different parts of the country, along our coastlines, in our islands, in our sensitive habitats, and many of the last best places in our country. So I think that tribes will have a role, and I think that the role of the federal Indian law practitioners would be to assist the tribes in basically deploying, figuring out how best to safely deploy their indigenous knowledge and to share it, with our federal land managers. I think there's a number of ways that it can be deployed with the help of Indian law practitioners. First would be for tribes it begins at home. Every tribe should have its own land ethic and water ethic based on its own traditional knowledge. A land ethic or a water ethic is simply a body of knowledge about a moral compass, I guess you could say, for land managers, on what is intrinsically right and what is intrinsically wrong when it comes to land and water management. And I think that's the missing ingredient in the United States. We have no land ethic. We've got science, we've got policies and whatnot, but if you look around a room and say, how should humans behave themselves or comport themselves to the natural world, we would get blank stares or maybe 50 different answers. It's because we don't have a widely shared understanding of dealing with the natural world, I guess. But I think it starts at home with tribes. They can enact their own. When I was leaving office, we were working on a Pawnee land ethic for the Pawnee Nation to underpin our environmental laws. Have to look within your culture, to your origin stories, to your teachings, to your ceremonies, and draw from that how humans are supposed to react to Father Sky, for example. Are we supposed to pollute it? I don't think so. It's a sacred place. And put that into your tribal law or your tribal policy to strengthen your tribal laws. If the tribes don't do it, then how could we expect anyone else to do it? And I think tribal land ethics is a part of their environmental framework, would establish a precedent for the federal agencies and ultimately the nation on how to have some sort of a moral compass when it comes to dealing with the environment. So that's one area of work, and then to also bring that indigenous knowledge to the agencies and under this joint secretarial order that I mentioned, and have that be part of their management decisions and their planning decisions. And ultimately to get a seat at the table when our nation finally sits down to try to forge a land or ocean ethic for the United States. The last area, the last challenge I see, and then I'm going to try to wind up really quickly here, is law law reform. Federal Indian law practitioners should lead the way to implementing the UN Declaration on the Rights of Indigenous Peoples into U.S. law and policy, our domestic law and policy. There is a need to reform and strengthen federal Indian law to make it a more just and a more reliable body of law to protect Indigenous rights in the United States. Federal Indian law, of course, is that legal framework for recognizing and defining and protecting the political rights and the legal rights of tribal nations and Indigenous peoples in the United States. And it's got two sides. This legal framework has got two sides. It's a federal body of law with two sides in it. It's got a good side and it's got a bad side. On the good side of federal Indian law, you see a lot of protective features for native tribes, mainly stemming from the doctrine of inherent tribal sovereignty and the trust doctrine. Under these protective features during the modern era, since 1970, we've witnessed great nation-building advances under these protective features of federal Indian law. That has resulted in the rise of our modern Indian nations that we see around the country today. But then on the bad side of federal Indian law, we see a dark side with very clear and very distinct anti-Indigenous features that come to us from the early international law of colonialism that was imported by the Supreme Court by John Marshall in Johnson v. McIntosh and its progeny in the 1820s. Includes the doctrine of plenary power, the doctrine of discovery, the doctrine of conquest, the doctrines of religious discrimination or racism, doctrines of unfettered guardianship. These doctrines that come to us directly from the medieval law of colonialism represent a dark side to the law through which we see many miscarriages of justice that is alive and well today in the body of federal Indian law, cited by the Supreme Court and lower courts every time they want to rule against tribal people. That renders all of our hard-won legal rights very vulnerable. Accounts for this 80% loss rate before the U.S. Supreme Court. There's a truism here, a great truth, that a race of people can only advance so far under an unjust legal framework. Advance any further in their aspirations, at some point in history, they have to turn and face those unjust principles and eradicate them from the body of law. That's the challenge, I think, for this class of 2024 to do that. The good side and the bad side of the law, they are constantly at war with one another, and an inherent internal conflict and inherent internal tension in that body of law that has to be resolved. And my generation, we never advanced a frontal assault on the dark side of federal Indian law. We just lived with it. Our strategy was to coax the courts and the Congress to employ the good side of the law, and we simply lived with the dark side. But I think it's up to this generation to reform federal Indian law and to discard this, once and for all, to discard this obsolete dark side of the federal Indian law and replace it with better human right doctrines that are found in this UN Declaration on the Rights of Indigenous Peoples. This UN Declaration, it creates a comprehensive body legal framework for defining the rights of indigenous peoples that are based on universal human rights. If they were incorporated, these standards of the Declaration, into federal Indian law, the result would be it would nullify the 10 worst Indian law cases ever decided, because those doctrines all come to us from the law of colonialism, and they don't pass muster under this UN declaration. The U.S. endorsed it in 2010, as has every nation in the Western Hemisphere, and all of these nations are in various stages of implementing it into their domestic law and policy. But here in the United States, the president has not ever met with the tribes to see how we go about implementing it in the U.S., to develop a national plan for implementing it, like they have up in Canada, which passed a national statute incorporating the Declaration into Canadian law. But I think that's the challenge of this generation. To do that, you have to be versed in international human rights law and social engineers like Thurgood Marshall, to reform federal Indian law and make it more just for the better. And that would be the hallmark of your generation, I guess, to do that. I think it would be the work of a generation, but it would be well worth it. So that, folks, that concludes my talk. Appreciate each of you for your kind attention, and thank you.
Thank you again, Mr. Echohawk. There were some very notable things that were said and a lot of good quotes taken. At this time, I'll turn things over to Mr. Austin Gillette, and he can explain this upcoming honoring that he will be rendering.
Go stay. You know, part of our culture that we natives have is that when you have an outstanding individual, we do what we call a praise song in his honor. So today I'm representing the Huntskudu. It's the Dead Grass Society, the Rickeraw tribe out of White Shield, North Dakota. I'm not here to talk about myself, but I'm here to talk about what the song is going to be. It's a simple song. It says, "The man who is standing here is outstanding." And also, what I have on my shoulder here is a Pendleton blanket, special made, about the Battle of the Little Bighorn, 1876. For those of you who may be historians, know that the Rickeraw tribe were scouts with the cavalry, starting about 1868. What's also, you may not know, that the Rickeraw War of 1823, when we were at the Grand River, which is down by Mobridge, South Dakota today, Colonel Leavenworth had about 700 to 800 Sioux with him. So we didn't necessarily join the Army because we wanted to, but we did it to protect ourselves and our way of life. And that's just part of history, and you and I can't control where we are born in, but we also should know about what happened in the past. So Walter, I'd like you to stand over here. He's down way. Hey, Hey, Duska, hey, dee dee, wako, hey, 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 do. Hey, Duska, hey, shukte, wako, hey, 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 Duska, hey, shukte, wako, hey, 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 Duska, hey, dee dee, wako, hey, 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 do. Hey, Duska, hey, shukte, wako, hey, 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 Duska, hey, shukte, wako, hey, 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 Duska, hey, dee dee, wako, hey, 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 do. Hey, Shauna, where's your tuck? What's your go stay? I said, Creator, thank you. Here, I won't take it all apart, but it's all yours. But the thing about this blanket is that those of you historians, you know about the Colonel, I can't remember what his name is, but Comanche was the horse, and it's stuffed down in Fort Leavenworth right now from the battlefield on the cavalry side. But this horse, this pinto horse of Bloody Knife came all the way back 500 miles to Lake Fishhook Village, where Bloody Knife and the Rickera Scouts were from. And so after he came back, we had ceremonies for it and never rode it again. And when they had ceremonies and all of that after war parties or whatever, this horse was included. Just fed him good, and nobody got to ride him anymore. But I got to mention today, a couple days from now, you'll be having the annual celebration for the Powwow Wachipi. 50 years ago, I was the president of the annual dance here. My brother Vance and I graduated with Masters in Counseling in 1974. But also, you know, there was a historical movement going on in the mid-'70s, early '70s, community colleges on reservations. Okay, Leonard Bear King, he was the head of the Indian teacher program here, and Dr. Vito Perrone was the head of the department. And Leonard Bear King asked myself and my brother if we wanted to write a grant to try to start a college at Fort Berthold. Long story short, we did. We got funded in October '73 for $640,000. Then we hired a coordinator, and in turn, the tribe did a charter and a board of directors, and hired a president. And so this month, we're celebrating 50 years of having our college at Fort Berthold. And so we have strong ties to UND. And we appreciate the support that we got and still do today. With that, go stay. Enjoy the day.
And through Austin's wonderful work, I am proud to say I'm actually a product of that tribal college. I graduated with both my associates and bachelor's degrees. So without the work of Austin Vance, who is an attorney, and Leonard Bear King, I would not be where I'm at today. So we thank you for all the work that you've done in Indian country as well, and your contributions. At this time, though, I'd like to turn it over to you all to ask Mr. Echo Hawk some questions, and we'll have mics going through the audience here.
As long as they're easy questions.
I'll start off, and I expect other people to join in. This is also, I think, supplemental to Mr. Echo Hawk's presentation and for the students who are here. So my name is Dr. Dave Wilson. I'm the Associate Vice President for Health Research here. I'm also the Chair of the Department of Indigenous Health, and I recently come from the White House Council on Native American Affairs, and also from the National Institutes of Health. So one of the things that I wanted to talk about was this new era of tribal consultation. I think it has also created an additional issue, And that issue is that many agencies are inundating you with requests for consultation. Those are meaningful consultations, although how do we design, or how do our law students here help tribal governments set up systems so that they can support those number of requests coming through so that there's meaningful participation by the tribe side? From the federal side, there were so many consultations that were really important, that we deemed as really important, where we saw minimal participation from tribal leadership, and it was very, very frustrating. So, I'm wondering, how long can that continue? On the federal side, where they say, okay, well, I guess the tribes don't want to participate, we'll go back to the old ways. That's one of the big concerns that I have. And then secondly, is that I think that with the Indian law professionals here, there's going to be challenges around the indigenous knowledge implementation, around intellectual property rights. And so how do you protect those rights while offering assistance and guidance to these federal agencies to preserve and restore the lands back to their original states where we're sustainable again, where we're living in healthy environments? That's a really important question. That's a hard question, and that's for all you to answer.
I thought the questions were supposed to be easy ones. As to your first one, you're right. As I mentioned, when I served as president of the Pawnee Nation Business Council, man, not a week went by when we did not get inundated with consultation requests from federal agencies. And so you're right on that score. Now, most of these consultation requests that I saw that came across my desk were, well, they were all important, but some were more important than others. In that we have capable tribal staff, our TIPO and our environmental staff, and other staff that part of their duties is to handle the day-to-day consultation requests that come across their desks. And in 99% of the time, they're able to do that. But once in a very great while, there's a huge issue that in a pile of consultation requests that is very, very important, that affects vital tribal interests, core legal rights, that requires the tribal government to muster its technical staff, its political staff, its policy staff, its legal staff to try to protect those core legal rights or tribal interests. And so we passed at the Pawnee Nation, under my tenure there, a Pawnee Nation government-to-government consultation statute. And it was triggered only when one of those kinds of issues came to the Pawnee Nation. And it laid out the free, prior, and informed consent consultation standard. It laid out a consultation process that was workable for the Pawnee Nation, that gave us time to assemble our team and the time to engage in a meaningful consultation that was workable for the Pawnee Nation. And so I think that that provides, and I'm working currently now with NARF to develop a tribal government manual or a guide for enacting tribal government-to-government consultation laws and policies. And hopefully that'll be out here in the next few months. But so that's one way to kind of maybe a statute that applies on the really important stuff where you need more time. The second area is that tribes need to have some internal capacity building when it comes to consultation. There was a time before the Trump administration where tribal TIPOs were able to charge money for fees that supported their work in consultation. And that was discarded during the Trump administration, and it hamstrung the tribal TIPOs from charging time for their own expenses in responding to these requests. So tribes need funding for capacity building when it comes to intergovernmental affairs in general. I think each tribe should have a lobbyist inside the DC Beltway that work for the tribe. They should have a intergovernmental affairs staff full-time. And I think that tribes need to upgrade their governments to make sure that they have the consultation teams and resources to effectively consult, on complex issues. And so that would be one answer to that. And I think the federal agencies also realize that the lack of tribal government capacity to effectively consult hampers this two-way street. And so, but do they cough up the money because it's expensive to field up your technical staff and your legal staff like that. But as to your second question, I'm going to defer that to the class of 2024. You're up.
Any other questions?
Hello, Walter. My name is Mary Baker. I am from Fort Berthold. I just want to thank you for everything that you spoke about today, because it does resonate very heavily into those that are tribal individuals. Like, I think nowadays kind of tend to forget our inherent stakeholdership into the United States itself. And when it comes to resource management and government-to-government consultations, on both sides, there tends to be a lack on creating a dialogue between professionals and those that sit in place and those that fill the seat for consultation itself. So thank you for bringing it up and kind of shooting off some really good ideas, because it is a movement that, we have to have that set. I think that there's a potential for a bigger movement in Indian country, because we're in the time now where these days we are either going to do something about our status of where we're headed in the world at a collective human race, but not only that, I think it's important that nation to nation, indigenous peoples, nation to nation, need to start working together too. And when it comes to speaking up for resources, not just them being resources, but sources of life, water, earth, air, are elements, and the environment itself, the things that we could do to protect or become agents to protect those things is important. Lack of capacity for combating, the things, tactics against the environment, just in the name of development or finances, or financial, whatever, economy. I know that I have a lot to say, and I probably am not making any kind of sense, but I just wanted to say thank you. There's those of us that have, open ears to mentors like you. You come from a whole another generation that you helped created that voice that you guys kind of helped break the path for us to follow. And I appreciate everything that it took, because it did take a lot of bravery to self-educate and trailblaze through professions that you might have not even been seen as a human being. Those braids mean a lot, and even how you carry yourself. Just want to say thank you, because I didn't know, even Austin, I didn't know that what you did for us to have a college at home. We had to go state it. But I just want to say thanks for bringing up those highlights today, because we do really need to start working together as Indigenous peoples.
Thank you. It's good to see you again. I should add that the Pawnees are related to the Rickraw people. And so these are my relatives here that from the Fort Berthold, the Rickraw people. At one time we were one tribe.
You mentioned the 10 worst cases in Indian law, and some of you might know that that's the subtitle of a book that Walter wrote that is really hard to find now. One of my colleagues had told me that it's out of print. He wants to know when there's going to be a second edition, because he's not going to pay $180 on eBay for one. But my question for you is, and I'm not going to ask you to make a top 10, but if you made a list of the best cases in Indian law, what might the 2 or 3 best cases in Indian law be?
Actually, I made a list of them in my book, In the Light of Justice. I think there's possibly a chapter in there on that. But the Courts of the Conqueror, the 10 worst cases, it is out of print, but it'll be back in about a month or so, back on the stand there. So just FYI. Well, I like the Standing Bear case, for example, in the 1800s, 1870s, I guess, on the northern Poncas. It was basically a civil rights case, a habeas corpus case, in which Standing Bear and the Chief Standing Bear and some of the Poncas did not like being relocated to Oklahoma, and they decided to return to their homeland in Nebraska. So they, in the dead of winter, they walked back to Nebraska. And when they got there, they were arrested and by the Army. And some of the local attorneys there in Nebraska filed a habeas corpus act that said no person can be detained illegally without legal justification. And they said that Standing Bear is a person, and he's been incarcerated without any legal authority in Omaha. And by golly, the federal judge in 1876 held Standing Bear is a person. And by golly, I cannot find any legal authority for arresting him and his people. And so he released him from jail. And this was a case at its time was when there was really no such thing for human rights, or much less civil rights, for Indian people at that time, especially on the Great Plains, which was one vast theater of warfare and removal of the tribes and placing them under the thumb of the government as a ward of the government. When you're a ward of the government can do things to you that it could never do to a citizen, And so the fact that the federal district court judge in Omaha ruled that Standing Bear was a person for purposes of the Habeas Corpus Act was quite a remarkable decision, and a one-of-its-kind decision, in the 1800s, that It was a short-lived decision because it never really caught fire in terms of its precedential value in the late 1800s, because that was a time of great oppression, and so it was lost into the annals of waves of history, I guess, at that time, but it was a pretty outstanding decision for its time and place. And there are definitely others that we had a lot of really big wins in the modern era of federal Indian law. As I said earlier, our tribal nations have made great nation-building advances, since 1970 down to the present date, on the backs of some very powerful Supreme Court decisions on economic development, tribal sovereignty, tribal jurisdiction, protection of all of these rights and government responsibilities. There's a bunch of them, so I don't want to paint a skewed picture, but there is that dark side of the law that really need not be there. We can rule our native people without resorting to unjust body of law in our democracy.
I think we have,
I'm thinking.
just,
As long as it's easy.
Hi, my name is Zach. Thank you for coming, Mr. Echo Hawk. My question is, among the people you've worked with, Native Hawaiians was included amongst them. Why, in your opinion, do you think they haven't sort of been more independent and have sort of more organized sort of organization, including reservations and whatnot, their own constitution and government?
Yes, I have a great high regard for our native Hawaiian relatives out on the islands there. Been out there many times and worked, on some legal issues with them, and come to highly regard them. They're just like Indians, their culture and their sense of humor and their way that they look at the world, really reminds me of a lot of the people around home and people that I know, American Indians, and so they have a very profound culture that looks at the ocean, and they've got a fierce determination, volatile people too, if you will. I've noted a lot of internal fighting amongst them, that I think retards their stride towards self-determination and self-rule out there, So I think that's probably the biggest stumbling block. They're not organized into tribes like we are here, which kind of makes things. Well, when I was out there, they looked up to the American Indians the first time I went out there. They said, "Oh, you guys went to war. You fought for your people. You shed blood, for your way of life, and we didn't do any of those things, and you guys got tribes, and you this and that." And they looked up to us, and I said, "Hey, don't look to us, we're the poorest of the poor, and we've made a lot of mistakes and blah, 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 but they're at the stage where their sovereignty, of course, they had a kingdom and that was overthrown by the United States, it overthrew their form of government, and they haven't been able to replace it. They can't agree on how to go about doing it, and I think that's their main stumbling block right now, but.
okay, we have time for one last question.
My name is Francis. Thank you for being here. I see we are approaching time, so be as brief as you need to be. What do you see as the biggest issue or issues tribes or individuals face when dealing with federal criminal law?
Oh, wow. In the criminal justice system, we have a high rate of incarceration in Indian country. Under the 10 Major Crimes Act, the federal government has criminal jurisdiction over tribal nations for the commission of one major crime as defined in that act by an Indian against another Indian. You know, the federal court has jurisdiction over that as opposed to tribal court or state courts. And so, and that's an incursion, I think, on our sovereignty. The Supreme Court prior to that act held that we had jurisdiction over major crimes, you know. But there's been a lack, I think, of adequate law enforcement protection by the feds, I guess, and possibly a lack of protections for women and children, you know, by the federal. They just don't have the resources or the interest, I guess. But then on the other hand, you see a disproportionate racially disproportionate number of Indians going to state and federal prisons as well, you know, with a very high incarceration rate. So there are issues and problems there. And I used to do a lot of prison work, you know, and saw the upshot of that in the lack of rights of Indian inmates. So I guess there are issues there, but it's been so long since I've really took a hard look at that, you know, and I couldn't really prioritize. And I should say too about these issues that I laid out in my talk that I saw as the 4 big challenges. That's just my own perspective. You know, there's other attorneys here that may have other issues. I'm sure we do, but just from my own perspective, that's what came into my mind as being challenges, you know, for this class of 2024.
Don't hate me, everybody. I know we're almost at time, but we have a unique opportunity because we have a lot of 1Ls here. And what would you say we're very blessed to be one of the few colleges in the nation to have a federal Indian law program. So what would you tell the 1Ls who are not necessarily of Indigenous descent to encourage them to study federal Indian law and tribal law here at the university?
Well, I think it should be a required course for purposes of the bar exam. There should be some federal Indian law courses, questions, you know, especially in states that have big reservations like North Dakota and all of the Great Plains states, you know, and Oklahoma, where, you know, we've got 39 federally recognized tribes. Just as a matter to have a well-rounded legal education, this field of federal Indian law, it really has you have to be versed in American history to really understand the principles of federal Indian law. It raises all kinds of political, tribal, state issues and water right issues as well, you know, and to live in a state and practice law, say in North Dakota, you know, it's just a thing that every attorney should have Indian Law 101 just to understand and for your client's sake, you know, whenever they run up against a Indian law issue to kind of know the ropes, so to speak, you know, because it's part of the political landscape here in North Dakota. Tribes ain't going anywhere, and they're a very prominent feature, you know, politically, you know, in the political system here in North Dakota. So I think it warrants some degree of knowledge, you know, by every law student, you know, and every attorney. And I think it would go a long ways towards, one of the challenge I mentioned earlier was we live in very divisive times, you know, and if you have an attorney that doesn't have any inkling of the complexities in the field of federal Indian law, would be very ill-equipped to intelligently advise a client that is dealing with a tribal nation or a federal Indian law issue that comes across their desk, you know. So there's a lot of reasons to take it. I think once you get into it, you'll find that it's a quite interesting body of law as well, you know. So I commend that to you.
We have some good sword that we do, but thank you all for coming. Please join me in thanking Walter and for